Welcome back to the virtual orientation for the University of Ottawa JD program. In this podcast, I discuss with Professor Vanessa MacDonnell a very complicated and perplexing question about the structure of the Canadian court system. We've already heard a little bit about courts and their role in the Canadian legal fabric. But who are these courts? What are their names? How are they structured? What do they do? Where do they lie in relation to one another in terms of a hierarchy? These are all questions that we address in the following conversation. I began by asking Professor MacDonnell to describe her professional background and teaching.
I'm Vanessa MacDonnell. I am a law professor here at the University of Ottawa. I teach evidence and criminal law. I joined the faculty in 2012. Before that, I was at the University of New Brunswick for 2 years teaching similar subjects. Before that, I practiced a little bit and clerked for Justice Charon at the Supreme Court of Canada.
Wonderful. And so we're going to talk a little bit about one of these perplexing questions that many students have when they enter law school, and that is, who are these courts whose decisions they spend so much time reading, and how are they structured, and how do they relate to one another? I wonder if you could just provide us with start with a general overview of the court system.
Sure. So sort of different aspects to the Canadian court system, and probably the most useful place to start is with the court systems that exist in every province. So every province has a system of courts, and starting out with the provincial courts, and then we have the provincial superior courts and the provincial appellate courts. So those are all what we might think of sort of together as courts that exist within the province. We also have a system of courts created by the federal government. So the federal courts, the Tax Court of Canada, and they have a very specific jurisdiction that we could talk a little bit more about. There's also the military court system. And then finally, we have systems of administrative tribunals, both provincially and federally. And administrative tribunals are what we call creatures of the executive. So they're created by the executive, but they function like courts in many contexts. So you might think, for example, about human rights tribunals in the provinces. They perform functions that are akin to the functions that courts perform.
So if administrative tribunals are created by the executive, then who creates the courts? Where do the courts spring from?
Right. So actually the Constitution has something important to say about the creation of courts in Canada. And you will have heard from Professor Dodek, I believe, about the Constitution generally, but the Constitution Act 1867 divides authority for the court system between the federal government and the provinces. So the federal government has authority to appoint judges to the provincial superior court, and they have to pay them as well. And then the province has jurisdiction over the administration of justice within the province. So when we think about the courts that exist within a province, some of those courts are provincially appointed, or the judges on those courts are provincially appointed. Some are appointed by the federal government. So we have that aspect of the court system, which is regulated by the Constitution. We also have Section 101 of the Constitution Act 1867, which vests authority for the creation of a General Court of Appeal for Canada in the federal government. And so that's where the feds got the jurisdiction to create the Supreme Court of Canada. And then as well, through that same section, Section 101, the federal government has authority to create other courts for the administration of justice within Canada, and using that jurisdiction, they created the federal courts.
So let's focus on the provincial side of the ledger. And so it sounds like there are two species of courts at the provincial level. There's the ones that have judges who are appointed and paid by the federal government, and then there's ones that are appointed and presumably paid by the provincial government. And who decides what architecture these courts will have? Do they have the same design in every province? Do they mimic each other across the country?
Right. So in the provinces then, like you said, Craig, there are two kinds of courts. So these courts where judges are appointed and paid by the federal government, and then courts where the judges are appointed and paid by the provincial government. So if you start with what we call the provincial courts, and the terminology here is a little bit confusing because we can talk about the courts that exist within the province, and there we mean both the provincial courts, what we call the provincial courts, and the superior court. So the term provincial courts is being used twice there, but if you want to start with what we call the provincial courts, these are sort of the lowest level of court in the province. These courts have jurisdiction that's determined by statute. So they hear mostly criminal cases, some family law cases, they hear provincial offense cases. These are busy, high-volume courts, and I encourage you, once you get to Ottawa and get settled in, to go over to the courthouse on Elgin Street and go to the bottom floor where the provincial courts are located, and just sit in the courtroom, and you'll see these are very active courts. And things move very quickly in those courts. So those courts deal with the bulk of criminal law matters particularly. So next we have the provincial superior court. So these are courts that are located sort of in the structure of the court system above the provincial courts. In Ontario, lawyers in these courts are robed. So they don't wear wigs, but they are robed. Now these superior courts are called different things in different provinces. So in British Columbia, for example, the provincial superior court is called the BC Supreme Court. In Ontario, we call it the Ontario Superior Court. In New Brunswick, it's the New Brunswick Court of Queen's Bench. So they're different. They're called different things, but they all perform a similar function, and they have what's called inherent jurisdiction. And what that means is that they basically have full authority to decide any case. Now, there's some exceptions, so some of their jurisdiction can be carved out and given to another court, but in general, they have unlimited or plenary jurisdiction. So those are what we would call the courts of first instance. Those are the courts that where trials are conducted, where matters are heard for the first time. From there, we have appeals.
And so just to come back to who's appointing whom, so the provincial courts, are those the courts where the province is doing the appointing and the paying of the judges?
Yes, yeah.
And the provincial superior courts, those are the courts where the province may create the court, but it's the feds who are appointing the judge and paying the judge.
Exactly.
And is there another name for the provincial superior courts that students may encounter?
You may see the provincial superior courts referred to as Section 96 courts, and when they're called Section 96 courts because Section 96 of the Constitution Act 1867 is the provision that provides that the federal government appoints judges to those courts and pays them.
Turning now to appeals.
Right. Again, we're still thinking about the courts that exist in the province. And if you want to think about the provincial courts, so those lowest level courts, their decisions can be appealed to the Superior Court in some circumstances and to the Court of Appeal in others. And so without getting into any detail there, the relevant rules are found in the Criminal Code. In terms of if you're dealing with a provincial court decision, what court that decision can be appealed to. Decisions of the provincial superior court are appealed to the provincial court of appeal, and these judges are also appointed and paid by the federal government. And what's different about the Court of Appeal, other than their function, and I can talk a little bit about their function, but one of the things that's different is that they sit in panels of 3. So what you have is a number of judges who are sitting together and who will deliberate at the end of a case, and sometimes they agree, sometimes they don't, and so you may get a unanimous opinion, but you may also have concurring opinions or dissenting opinions. And I know you're going to learn about how to read a case, and so you'll have an opportunity to think about all of these different kinds of decisions. So those are the provincial courts of appeal, and then Court of Appeal decisions can be appealed to the Supreme Court of Canada. And so the rules at the Supreme Court of Canada are a little bit different in terms of how appeals proceed. Again, judges of the Supreme Court of Canada sit as a panel of 9 justices, and in order to appeal a decision to the Supreme Court of Canada, it's usually not just a matter of filing documents. So for the most part, to get your case heard by the Supreme Court of Canada, you need to be granted leave, which basically means you need permission. There is an automatic right of appeal in a very limited number of cases. So in cases where, for example, there's been a dissent in the Court of Appeal on a question of law, but for the most part, you need permission. And so in the last few years, the court has heard between 70 and 80 cases a year. About 25% of those cases are appeals as of right, and the rest of those cases are cases where the court has granted leave or granted permission for the appeal to be heard. Another sort of interesting feature of cases that we sometimes see at the Supreme Court is that the statute that creates the Supreme Court Act, contemplates that the federal government might refer certain legal questions to the court and ask for the court's opinion. And so usually where there's a reference, these are sometimes called references or advisory opinions, usually those advisory opinions deal with constitutional questions, but those are sort of an interesting feature of the Supreme Court's docket that we see from time to time.
Do you want to say a few words about the mechanics of how proceedings work in the Superior Court and the idea of trials?
So generally when a case is heard, when a case is going to trial, the evidence in that case is brought forward through the testimony of live witnesses. And so that's what we call viva voce evidence. So most trials involve this evidence that's tendered through the testimony of witnesses. Typically what happens is a party will call witnesses and they'll examine that witness in chief. The opposing party or parties will then cross-examine the witness. So once all the evidence is in, and of course there can be documentary evidence, not all evidence is oral evidence, but after all the evidence is in, the lawyers make legal submissions, so they present the court with legal arguments about how they believe the case should be resolved, what the relevant legal principles are. And then if you're dealing with a jury trial, what happens next is that the trial judge, even in jury trials, you still have a trial judge that controls the proceedings and importantly instructs the jury as to the relevant law, because juries are what we call triers of fact. They get to decide what the relevant facts of the case are, and they apply the law to those facts, but they don't have any choice about what the relevant law is. So the trial judge instructs the jury about what the relevant law is, and then the jury goes off and deliberates. If you're talking about a trial by judge alone, what happens is, depending on the kind of court, the kind of matter that you're dealing with, in the criminal context, sometimes you get a judgment on the spot. If you're in one of these very busy courts and the matter is fairly straightforward, sometimes the judge will recess for 15 minutes and come back with a decision. Where you're dealing with a more complex trial, though, what usually happens is that the judge will reserve and then issue reasons for a decision later.
Where are jury trials more likely? You've mentioned criminal cases. Do they also arise in civil causes of action?
Yeah, so jury trials are a feature of both criminal and civil matters, although really jury trials are most prominent in criminal trials. We still see the jury still plays a very important role in criminal cases. It's less common in civil matters, but in general, it's just less common for civil matters to go to court. Period. So we really see the jury used still with some frequency in criminal cases.
And what about on appeal? How is the process different on appeal?
Yeah, so the appeal process is different. So in the context of an appeal, the Court of Appeal doesn't sort of start all over again when they hear an appeal. So what they do is essentially proceed on the basis of the record that was created at trial. And when we talk about the record, what we mean is all of the evidence that was heard at trial. And usually what appeal courts are doing is examining the initial decision maker, the judge at first instance, and determining whether that judge correctly applied the law in the particular circumstances of the case. So did the judge describe the law correctly and then apply that law correctly? And so in that process, the Court of Appeal is really performing a review function, and the review function is limited. They're really focused usually on the legal issues that were raised by the case and if the judge dealt with those legal issues properly.
It sounds like it's very difficult to appeal fact.
Yeah, so there's basically a different standard for appealing questions of fact and questions of law. And in fact, it's very, very difficult to overturn factual determinations that were made at trial, and appeal courts in general don't have a lot of time for arguments that rest on trying to convince the court to take a different view of the facts than the trial judge did. At the same time, it's not impossible, so if there was a grave factual error that was made by the trial judge, that could be the subject of a successful appeal. But for the most part, we're really confined to looking at legal questions, because the view of our legal system is you have to get the law correctly. So and so that's the reason why appellate courts are very much focused on how the trial judge applied the law.
One final question before we end. You teach in the area of evidence, where, of course, matters of what you do at trial come up all the time. That's an upper year course, but maybe for the purposes of our listeners, you could just describe what we mean by the rules of evidence.
Right. So essentially, when we talk about the rules of evidence, we're talking about a few things, but primarily the rules that govern the admissibility of evidence. So the rules that determine whether evidence is heard by the trier of fact, so by the judge or the jury, or not. So the overarching principle in the law of evidence is that any evidence that's relevant and material should be admitted in evidence. But the second rule of the law of evidence is that, or there are a bunch, I guess, of secondary rules of evidence that provide that certain types of evidence are presumptively inadmissible because their admission might cause the trial judge or the jury to draw the wrong conclusions about certain aspects of the case. So these are rules that sort of govern whether that evidence gets into the record, whether judges or the trier of fact get to ultimately hear and rely upon that evidence. And so most of the law of evidence is concerned about questions of admissibility. It's also concerned with ultimately what you do with this evidence once it's admitted. And then there are a bunch of peripheral issues that we deal with. I guess maybe they're not entirely peripheral, but issues around the calling of witnesses, for example. So are there certain kinds of witnesses that we need to be particularly careful with? Are there certain types of witnesses who shouldn't be allowed to testify? So should a spouse be allowed to testify against his spouse in a particular matter? So issues around witnesses also come up. And then, of course, since 1982, when we got the Charter has also had a real influence on the development of the rules of evidence and our understanding of whether evidence that's been obtained in violation of the Charter should be excluded, whether it should be heard by the trier of fact or not. So the Constitution also figures prominently in that discussion.
Thank you very much, Vanessa.
Okay, thanks.